new stitches, but she'd rather not put them in, as long as I didn't mess with my head, because the skin was already healing nicely. She said she didn't have to put stitches in right away.
Where you from? Where you from?
My primary care.
Does it give you any after-pain troubles or anything?
Medicine, and she gave me a referral for an ENT because she said that the swelling wouldn't let them do anything to my nose right now. But once the swelling went down, if I had a deviated septum or a disfigured septum, they would be able to fix it, but there's nothing they could do right now.
Okay. Let's go back to your hospital over there. You can see this person has a second. I'll just back over a second. Let's see.
You see this person?
Will help as far as injuries documented, something like that, if possible.
I'll ask her for them.
Yeah.
She made note of everything.
We have notes. Yeah, just has to get the back of his head. That's butterfly.
I said, do you want me to move or you move? Sorry. Moving also.
It's always better to have you say a couple words to her about it.
Oh, she said I had a...
Brother saw something that we needed to know. It's always better to have
Stained SI. Something about my sciatic something. She gave me just this scrapes there. I don't think so. No, I had a long sleeve shirt and a jacket on top. So. It was just focused on my head. There's a little bruising there. There's a cut here.
Swelling like that, because I remember yesterday, I remember seeing swelling around right here, and I don't see it now.
My wife is a NARU student, so she went to work. She's a good looking.
Thank you. This is a complete copy of those. I guess this needs to be put into evidence. I would get a copy for the state, but I know they already have it. But these are all 11. That is an entirely composite exhibit. To identify for purposes, it is all of the video statements, audio statements, and written statements from my client. Next composite, Your Honor, is a composite exhibit documenting injuries sustained by my client. My approach as well, except those, a composite exhibit of 9 pictures of the injuries my client sustained. If you take a look at it, it begins with the ABC News exclusive that I think was shown in the courtroom before. Next on those is a picture taken at the Sanford Police Department after my client's wounds were attended to by EMTs at the scene. Next one is a close-up of those same wounds, documenting in the upper right-hand quadrant the injury to his skull. Next one is his injury to his nose and his face shot.
Move those into evidence at this time? Mr. Romero? Yes. Move those into evidence at this time? State?
I'm not going to object to it, Judge. That's fine. Court's already seen him, so I don't...
next, Your Honor, and it may have been included as that composite, but this came from a different source. This is actually a third exhibit that I'd ask you to consider, which is a cell phone video taken by a witness at the scene directly after the injury. It's significant to the extent that it shows the injury to my client's nose and the blood around the nose and mouth.
Again, the court's already seen these, but I have no objection.
Defense Exhibit 3 will be admitted.
I'm hoping that at least as to witnesses we can bounce a little bit because Mr. West is going to present a witness.
We would call Kevin O'Rourke.
May be required?
Yes, sir. Frequently. Absolutely, we do it every shift.
What station are you associated with?
I work at Station 38.
Assigned there.
Almost 4 years.
Were you working on the evening of February 26, 2012?
I was.
And what were your duties that night?
I was driving the rescue and attending to medical calls.
Did you have occasion to respond to a call in the vicinity of Tree View Circle?
Retreat View Circle? Yes, I did.
And do you recall where you were when you got the call?
We were en route from the hospital from another transport, and we were almost at the station. We turned around and we headed to Retreat View Circle.
And about how far would you estimate between the station and Retreat View Circle?
Approximately 3 miles. Took us about 5 minutes to get there, I think.
So you think your response time was 5 minutes or so?
That sounds about right.
When you got there, were you asked to look at the condition of an individual who had received a gunshot?
Yes, we were.
Was that your first responsibility once you got there?
Yes, it was. Yes, we did.
Were you then asked to attend to George Zimmerman?
I was.
And where was Mr. Zimmerman when you first saw him there at the scene?
He was sitting with his legs out of the back of a police car, I think.
Were you with other firefighters as well?
Yes, I was. I was with the entire 38 crew, engine and rescue.
And you recall who was with you in attending to Mr. Zimmerman?
I do.
Tell us who those individuals were, please.
On the trucks that day, it was myself, Mike Brandy, Stacy Livingston, Tyler Rochefort, and Lieutenant Mike Turner.
When you approached Mr. Zimmerman in the patrol car, were you there to assess his injuries and provide the initial treatment?
Yes, we were.
And what did you observe about his physical condition?
I observed that he had blood on his face and the back of his head, and that was about all I remember as far as his injuries. I think he had a cut on his nose as well.
What's your job at that point?
Our job was to basically clean him up and treat his wounds. They weren't bleeding when we got there, and we spent a good 5 or so minutes cleaning him up and clean him up with hydrogen peroxide, and we gave him an ice pack, and we assessed his level of consciousness and his alertness. That's what we did.
So you took some gauze and some peroxide and began to wipe away some of the blood that was on his head and face?
Yes.
And when you first saw him, you would describe it as a significant amount of blood?
I would.
An estimate, perhaps, or maybe almost half of his head and face was covered?
I believe I stated earlier 45%, a good 45% of his head and face were covered in blood.
Once you got cleaned up enough that you could see the extent of the injuries for which you could treat, you then realized that he had some lacerations to his face and head?
Yes, we did.
And at that point, what did you do?
At that point, we recommended that he get looked at by a doctor within the next 24 hours. He didn't want to go with us, and we're fine with that.
I'm sorry.
I'm sorry?
I didn't hear what
We
you said.
requested that he get looked at by a doctor sometime within the next 24 hours because his lacerations on his head would probably need stitches.
Did you suggest that he go to the hospital at that point?
I believe one of us did. I don't think I did personally.
Mm-hmm. And would that suggestion be made to law enforcement? Apparently he was in custody at that time.
When he was in custody at the time, yes, we told them that if he didn't get looked at by a doctor with us, that maybe the doctor at the jail or wherever they were taking him should probably give him a look over and see what was going on.
Your assessment was he might need some stitches and he should definitely see a doctor.
Yes.
One moment, please. May I see Exhibit 3? Mr. O'Rourke, I'd like to show you what's been admitted as Exhibit 3. May I stay here for a moment, Judge?
Sure.
Looking again, this is a cell phone picture that was taken there. I wanted to ask you about the nose.
Okay.
You remember seeing Mr. Zimmerman's nose and noting its condition?
Oh, yes. He had a laceration across the bridge of his nose and a pretty significant amount of blood in his mustache and on his goatee.
And did you consider that it was likely his nose was broken?
Absolutely.
It was swelling and
there was swelling and blood, and his nose was obviously deformed from what it usually is.
Thank you, Mr. O'Rourke. Tender the witness.
Good morning, sir.
Good morning.
Now, you've got a little bit more hair than I do.
Yeah, almost.
But isn't it true that people who don't have a lot of hair on their head, when they leave, they need to lose profusely when they get injured, correct? And what I'm trying to get at is, based on your experience, people who have like a cut to their head bleeds a lot in terms of your veins, etc., when you get a cut in the head, correct?
Yes.
Disproportionately in terms of further services and all that.
Yes, your head's very vascular. It bleeds.
Tell us a little bit about that if you could, sir.
Regardless of whether you have hair or not, any sort of laceration or cut to your head will cause a pretty fair amount of bleeding.
Disproportionately to a cut like you're on your arm or something like that is what you're doing. Okay. Now, you did not diagnose that he had a fractured nose at all, did you?
No.
All right. And in fact, my recollection of your testimony, and I think I've spoken to you before, but I don't remember. But is that really you all treated him, cleaned him up?
Yes.
When I say you all, it was a group of you, correct? I think it was Livingston was there too, and there was a few others, correct? And you all treated him and then just let him go, correct? Okay. You didn't take him to the hospital or anything like that. It was not a life-threatening injury, correct?
Not at the time, no.
And I think you stated that he should have it checked the next day, correct? That's what you suggested.
Yes.
Okay. Now, I believe there was also a report authored by, I believe it was Michael Brandy.
Yes.
Okay, because he was the only one that wrote the report in this case.
Yes, sir.
And I believe he documented the injuries as minor bleeding. Would that be accurate?
If that's what
I can quote to you if you want.
if that's what he wrote, then yes, I'll agree with that.
That he had some abrasions to his forehead and bleeding tenderness to his nose and a small laceration to the back of his head. And I can show that to you. Am I going to push the witness, Sean? Just so you can look at it at a time. I believe it's patient number 1 there.
Yeah.
Okay, do you see that there documented?
Yes, sir.
Okay. And you also stated that document that. Thank you, sir. So you would agree with that documentation?
I would.
Okay. You also stated that you also dealt with the other person that was there. Now, tell us if you could what his injury was.
He had a gunshot wound to the upper chest area.
Were you able to speak to him?
No, we were not.
He was deceased.
He was deceased upon our arrival.
Did you notice any kind of weapon on him when you observed him?
No, sir, I did not.
Probably have no one. Take your time. I don't have any further questions. Thank you.
Yes, thank you.
Mr. O'Rourke, the extent of the bleeding is, the description, I suppose, is a bit of a term of art as used by personnel in your profession. What might be considered minor bleeding might in fact suggest that half of the face and head was covered with blood.
That would be correct.
Because that's what you saw.
That's what I saw.
You also saw the abrasions to the back of the head that were described. And those abrasions that you saw were serious enough you thought that Mr. Zimmerman may require some stitches.
That's correct.
And that's because his head had been banged into something hard.
I couldn't say, but he had lacerations on the back of his head.
So his head was banged into something harder than his head was. Consistent with the injury that one would get by having one's head
go somewhere else.
Is the injury that you observed to the back of Mr. Zimmerman's head, the lacerations, consistent with having had impact with a hard object?
Yes.
You just don't know what hard object that might have been.
That's correct.
The head, the scalp, has lots of capillaries, lots of vascular structure, so it does bleed quite a bit.
Yes.
The head is also subject to injury, neurological injury.
That's correct.
You get your head hit hard enough, you could have a concussion. You could lose consciousness. Correct?
That's correct.
And you could indeed have a life-threatening injury.
That's correct.
So one would be very sensitive to the extent of the harm that would be caused by having one's head hit on a hard object.
That's correct.
Thank you.
You didn't diagnose, any member of your team did not diagnose a concussion at all, correct?
No, we can't diagnose a concussion in the field.
Right, but there was no evidence to indicate that.
Not with us. He was alert and oriented ×4. He knew where he was, who he was.
Right, and he didn't have any skull fracture that you saw, correct? And you can't state whether the injuries you observed with the abrasions on his head were either whether he was the aggressor or the other person was the aggressor. Can you? Thank you very much. Is this witness be excused?
Yes.
Thank you, Your Honor. Yes, Your Honor. You're excused. You call your next witness.
Some of the submissions of evidence that may avoid the need for testimony on, if I might. They've been previously identified, certainly forwarded in discovery. These are my client's medical records from the Altamont family practice. Received, documenting his receipt of treatment on the next day by Ms. Holgate.
I do have an objection to this particular document, and I would like to question the witness who actually offered this. This by itself is not relevant unless the witness actually testified offering for Mr. Mayor.
I'm sorry?
What purpose are you offering?
Documenting what was seen the next day when he was seen. This is a diagnosis of some injuries. Ms. Holgate is, so that's why I'm offering it in this bond hearing, which...
Did anything further? No, Your Honor. Be admitted.
I believe would be before. And I don't know, Your Honor, if you've had an opportunity to actually review this document yet, so I would just... Oh, no, I don't believe you have, which is why I definitely wanted it before the court. I would ask that you focus your particular attention on the injury sustained, which suggests she adds codes to it, but an open wound of scalp without mentioning complication, nasal bones, closed fracture, assault by other specified means, and an observation following the inflicted injury. Also note what was identified as a sacroiliitis, which was a injury to the lower back. And would ask you just take a moment to review her suggestion of the scalp lacerations, and her identification is what she suggested or diagnosed as a broken nose. Okay. Also, that she suggests that my client, having gone through the trauma the night before, should see a psychiatrist or psychologist to attend to those injuries, and that she prescribed additional pain medications for his injuries.
And I guess if we're arguing, may I alert the court to a particular part of that document since we're...
Yes, sir.
I would alert the court to, first of all, a history of present illness is obviously the defendant's, as the court is well aware. But the defendant, that is the patient in this case, was told in terms of coming back for further injury, there's no evidence, or treatment, and there's no evidence of that on their page number 1 of that report, in terms of coming back. It also states that he was told he had a broken nose and denies being taken to the hospital. He then returned to work and was told that he needed a police report, so that's why he went to the doctor. And so I would just highlight that to the courts in terms of, if we're talking about the document, I would just have the court and also and medical clearance. So that's the reason why he went to the doctor.
I concur. He definitely decided to try and get back to work as quickly as he could after the event of the night before. But in seeing a medical professional, she said what she said, and you have the reference to it.
The witness, please.
Next exhibit would be the computer analyzed voice stress analysis, Your Honor, that was forwarded in discovery. This would be number 5. We're asking the court to consider that.
And I would object to it, Your Honor. It's not admissible in court.
The same.
You know, I might be heard. In a bond hearing, though it may not be admissible in front of a jury, for the fact finder, I think it does offer this indicia that you should consider. It is consistent completely with all of the other evidence that you now have to consider concerning my client's statements, which are now in evidence, which support all of the interrogations that he had done with law enforcement. This is, of course, a tactic or technique that law enforcement use throughout the world, and they use it primarily to identify a suspect to focus on or to exclude from focus a suspect in the case. So, though it may not meet a 5 standard for entry for the purposes of substantive evidence, it is corroborative evidence for you to consider in relation to everything else you're going to have to consider for a bond hearing. And I remind the court that it was this very court's order that suggested the strength of the state's evidence is one of the concerns that you had. So within that standard, I would ask you to consider it for that limited purpose.
And again, I would have the same objection to admissible. It's been refuted as being reliable, and I mean, if we're going to get there, we can bring witnesses that would refute that. And just like polygraphs, they're not admissible in court, I would ask the court to not even reconsider it because it's not admissible.
Or not admissible.
This one, then I should. Well, actually, I would like more for purposes, even though it's not going to be
Mark for the application as.
Well, we have witness statements and we have witnesses available. These are witnesses who have been, their secrecy has been maintained. So I'm going to seek at this point to enter their statements. We have the same concern. The state may want to editorialize on the statements, and we do have the witnesses present, but for the somewhat informal purposes of
bond hearing, I would like to address it in this way. So first, I would suggest the statement, witness number 6. It is a composite exhibit including the transcript, a FDLE summary, an FDLE summary of that interview, a second FDLE report, a written statement by witness number 6, and a transcript of a 911 call placed by that person. And yet another FDLE report. So I would move this into evidence as a composite exhibit on as alternative testimony to witness 6 live testimony.
We would object to it, and I agree with Mr. O'Mara's feelings in terms of this witness obviously not being name not being publicized. First of all, this is not subject to cross-examination. Second of all, I don't think it's a complete, because I know this witness number 6, if my records reflect, I myself spoke to him and took a sworn statement from this witness, and I don't believe that's part of the package. Unless I miss, I did not hear Mr. O'Mara when he presented the package to the court. So those are my 2 objections. But the main one is, as witnesses, if we're asking the court, because the court already had an opportunity to review all these documents in terms of when we were doing discovery for redactions or whatever. And so with all due respect to Mr. O'Mara, he now wants to present this without possibility of cross-examination. I think that would be pertinent to that. Now, how we could do that, whether we do that outside the presence of the public, in terms of keeping this witness name in photograph, etc., still concealed. But those are my 2 objections, Your Honor.
As to the first objection, Your Honor, I've noted on 3 occasions, I believe, at the last bond hearing that this is in fact a bond hearing and the evidentiary basis is somewhat relaxed. To the extent that it's incomplete, if we were given it by the state, it should be in this packet, and if not, we have it, and we will complete the packet before the hearing is up. But you have had an opportunity to review them for purposes of determining whether or not they should be protected. You do not have them in front of you as evidence. And I do think that it's necessary that we have an evidentiary basis for your ruling on the bond issue. So,
one final thing, if I may, Your Honor, the transcript that has been submitted, it hasn't been authenticated in terms of, I'm not saying that anything, but then the recording itself speaks volumes in terms of what, and I'm not implying in any way that anything improper was done, but I'm just saying,
I concur. Rather than the transcript, then, Your Honor, I would play the actual audio tape. We have that available. I'm wondering if I might just submit that to the court. I'm trying to think of how long it is. And I also want to be a bit concerned about redacting anything necessary about the witness. So, sorry for the informality, but I would like to submit with the state's, understanding the state's objection regarding the transcripts. We will remove those and submit for your consideration the actual oral statement or the audio recording. And I'll present that as soon as we put it together on a thumb drive for you. So, I think that's the best way to handle it.
Say, don't you agree?
yes, Your Honor. But the only thing I would request, well, we could still make the same objection, but I know the court will review it quite frankly. But I would ask that.
I understand what Mr. O'Mara's doing. Mr. O'Mara needs some evidence in the hearing for this one. That's what he needs.
I would just ask that the record be complete in terms of all the statements made by that witness. And I don't think there's going to
It's that composite along with the voice. Correct?
Along with the voice, that's correct. And if Ms. Delionda is suggesting that one of the transcripts of his interview with him is not here, maybe he has an additional one. I'll add it right now. But I don't know that we have that.
So we will complete that package before the day of the hearing is up. With those concessions, then I would submit this as evidence. I would ask to take a
Composite exhibit, exhibit 6, and what I'll do is I'll trust both of you when you get back, if you think there's something else that needs to be supplemented with respect to that, you can go ahead and forward it to me.
I would ask, Your Honor, if you would just take, I would ask a moment that you take a moment, Your Honor, and just review at least the 1/2 of 1 page written statement by witness 6 now, just because I think it's short, quick, and quite to the point. Thank you, Your Honor. Similar position with witness number 11, Your Honor. And if you just give me 1 second, I will.
Mr. Mayor, is that a composite exhibit also for?
Yes, Your Honor. It's under the similar issues with the previous one.
Possibly have to go someplace, or? You got a good scene.
I would review this evidence as well.
Thanks.
Again, I would just ask that if they're going to introduce it in the recording itself, I don't mind if the transcript is an aid to the court, but
we'll do that.
In terms of just being complete.
We will do that, Your Honor, and I'll just simply put all the ones that we can do on one side and available to you.
To do 6, 11, and whatever else you're thinking about.
And 20, Your Honor.
6, 11, and 20. I'm going to keep them as individuals, so that will be State 5, Exhibit 5 for Witness 6. Is that correct, Madam Clerk? State Exhibit 6 for Witness 11, and State Exhibit 7. Let me hear what the state's position is on that, same as before.
Yes, Your Honor.
That is 20 next, and we'll present
the Witness 20. Okay, those will be admitted. If it's 5, 6, and 7, also composites.
I might just have a moment here.
Your Honor, while Mr. Moore is taking a moment, may I ask you a question? The exhibits that are being offered to you is exhibits 5, 6, and 7, which I understand to be the statements of witnesses 6, 11, and 20, respectively. Are they going to be provided to you in redacted form from Mr. Amaro when he gives you?
I didn't hear that. I apologize.
I think that's what the state's position was. They didn't want anything redacted.
Well, the names of the witness I don't want redacted. I do want redacted, and the address.
Claims just what, as far as the identifying information of who made the statement will be redacted.
That was my intent, that we maintain the secrecy the court has afforded those witnesses.
Oh, that's fine. I have.
And
not a problem.
And just for purposes of the court, that I may address in terms of those have already been provided to the media in terms of redacted.
But I just wanted to make sure that what you're getting is what we had got, because if you're getting something with the names on there, that would change the dynamics of it.
Categorize that as a nice try.
Right.
Mr. Romero, Mr. Romero, I read the written statement of witness 20.
Next, Your Honor, would be the medical examiner's report on the decedent Zimmerman.
Often that as composite or
That actually is its own exhibit.
okay.
So,
Just state.
You know, I have no objection other than, I don't know if they have some information on the victim's family on here. I know you've got the whole package. Usually that they would contact the victim's parents, and so I would request their names obviously are public, but I believe it may have their addresses on there. And so if it does, I would just request that that be redacted before it's tendered to the court, or at some point while tendering it to the court, so it does not become subject to public records, because I think their privacy.
with that caveat, Your Honor, we'll attend to that as well.
Right now, you're going to do what? What that report says?
Right now, I'm going to hold off on it. I think the only state's objection is to make sure that we've redacted victim information that's still private.
So
And,
once you do that, and you can see the copies, pull the copy, once you redact it to the state, then you can send that to me, okay?
Yes, Your Honor. Next, Your Honor, would be a composite exhibit, photographs taken from what is now known as the 7/11 video, documenting Mr. Martin at a time just prior to his passing and the event surrounding Mr. Zimmerman.
No objection.
You said exhibit 9, 7/11 photos composite.
I'm wondering, Your Honor, if this might be an appropriate time for a 5-minute break. I may be able to abbreviate some more testimony, or I can keep going.
Think about it. Just at this time.
Let's say what?
Yeah, right, yeah.
And certainly that it is at least very weak, because what we do have now, and these statements are before you, is an extraordinarily strong argument of acting in self-defense, based upon a belief that Mr. Zimmerman, based on his statements in his own words, was in fear of great bodily injury at the hands of Trayvon Martin. The reality of what happened that night is that my client had his nose broken or fractured, and it was bleeding all over the place, 45% of his head, and that his head was smashed against some hard object, seemingly, according to the witness statements that you now have before you, witness 6, 11, and 20, that it was the sidewalk that Trayvon Martin was on top of him, MMA style. Those are the words of witness 20, witness 9, I'm sorry, said that he was pounding on him. Witness 9 said it was what they call in MMA ground and pound. When you get on somebody, get on top of them, hold them down, and wail on them with your hands. until they either submit, although nobody knew the rules there that day. My client certainly doesn't suggest in any of his statements he understood rules of MMA fighting. And then there was Mr. Martin. And I don't make light of it when I say that if Mr. Martin was shot because he had broken somebody's nose and he had gotten him on the ground and he had smashed his head against a cement walkway at least twice, and if you look closely at the video, maybe some other times, because the side of his head looks scraped as though it went up against sandy cement, then he got shot and he was killed because of his own doing. And that's why you need to be aware of a self-defense presentation apparent in Mr. Zimmerman's statements, and the state's case is so extraordinarily weak that you should not consider a significant bond. That's why I presented to you, Your Honor.
Thank you, Mr. Mayor. Your Honor, I'm not here today to try the case. We're not here today either to have a stand your ground or self-defense hearing. I welcome that, because quite frankly, that would require the defendant to take the stand and explain. All that evidence that the court heard in terms of defendant's statements, that's not admissible unless the state introduces it. He's got to testify, and then he would be subject to cross-examination, which is the key part about self-defense. That is, the person who claims it actually has to take the stand under oath and be subject to cross-examination. So I respectfully disagree with Mr. O'Mara in terms of the weaknesses of the case, of the state's case. You know, just for a minor point, the court has before it, one of it is the diagram, the Google of the apartment complex, or townhouses, whatever you call it. The state's contention is what the defendant was doing is he was targeting, profiling this, what he perceived a criminal, and he was making sure that in his mind, the person he perceived the criminal didn't get away. He was trying to act like a police officer, but he wasn't obviously authorized to act as a police officer. As the call that he called, the non-emergency call, they told him to back off or to get back. He didn't. He runs after this person. He takes him down. And our contention is that he's the aggressor, that the person who actually has self-defense is the victim, Trayvon Martin. Now, the court has listened to a lot, and when I say listen in terms of reviewing it for purposes of whether it's subject to public record, and one of them is the interview of the girl who was listening to the victim as the defendant was chasing him. So, but again, I don't think at this point we're here to try this case. Maybe because we have all the public here, but that's not the state's position in this case. We're here in terms of a bond. What's a reasonable bond? Now, Mr. O'Mara claims that it's relevant to the court in terms of the strengths or weaknesses. I respectfully disagree in this aspect. I think the case is strong. We have the victim's parents who say that's the voice of the person screaming as the victim. We have the inconsistencies, and there are plenty of them, of the defendant's inconsistent statements to the police, where they finally, in one of the last interviews, I believe it was Detective Sereno, actually challenges him and says, well, hold on, doesn't make sense. And then at some point he goes, well, I don't remember. He starts backing off all this stuff. One of the most classic inconsistencies, how could he be screaming if the victim has got one hand over his mouth and one hand over his nose? And to go to one of the arguments made by Mr. O'Mara, and I believe it was witness number 6, if the court were to review all of that witness's statements, because I interviewed him myself, I placed them under oath, and there's a recorded statement, he says he's not sure as to who was on top, and that he overstated the MMA wrestling. We also have witnesses who observed one individual chasing another, which I would submit is consistent with this defendant chasing the victim in this case. But the bottom line before this court is that we have an innocent victim. Now, why on earth was one of those photographs of the 7-Eleven put into evidence? Is the implication that it's somehow Mr. Martin, because he was wearing a hoodie, is a criminal? You know, I think that, you know, in retrospect, that photograph speaks volumes of what we have before you. And when I say that is, imagine if you could, Your Honor, who is more likely to get robbed on a regular basis other than a clerk at the 7-Eleven store? Did that clerk who dealt with Mr. Martin perceive Mr. Martin as a threat because he was wearing the hoodie? No. He treated him as a customer.
guy bought something and left. And so in retrospect, that is a good photograph that was introduced into evidence in terms of the court considering it, because somehow the implication is that he's a criminal because he's wearing a hoodie or because he's walking back to his house, and apparently he's not walking fast enough or running as Mr. Zimmerman, the defendant, claims he is. What you have here is basically a defendant who perceives himself as the police out there, whatever reason, and is tired. Maybe in the past there were for whatever reason people got away and they all have to be black individuals, but he perceives this victim as a criminal. He chases him, and at some point the victim does hit him. I mean, but the bottom line is banging. There's no evidence of that. There's no evidence, and nobody has testified to that effect. The defendant claims in his statements to the police. I would submit that the injuries are inconsistent with being his head bashed. If the court, and I know the court has already reviewed it, that interview, he describes being bashed, beaten. Those injuries are very inconsistent. He doesn't have any skull fractures. He doesn't have any kind of concussion from that. And so, again, we're not here to try the case, but I needed to respond to Mr. O'Mara's argument. So the gist of the issue before the court is, what happened here on April 20th? And why did that happen? Was it a person who came out of the street and just said out of the blue, oh, I've got some statements, and just misled the court? I would submit lied to the court? No. It was a person who was intimately connected to the defendant. The court has been presented 6 interviews or 6 tape recordings of the defendant's statements when he was talking to his wife and other family members. Quite frankly, we've got like 30 plus of them, in which this defendant spoke to his wife, Shelley Zimmerman, and they used code, they used other words other than $9,000 to make sure that whoever was listening wasn't aware of what was going on. Why was that done? It was done to hide the money so that they could deceive the court, lie to the court. Ms. Zimmerman lied to the court, and this defendant just sat there and allowed that to happen. Because he, quite frankly, was manipulating the whole thing. He was using his wife as a conduit to do this. That's why there was an exchange of money or a transfer of money from PayPal to his account, then later to 2 separate accounts, and then after he got out, back to his account again. I commend Mr. O'Mara in that he found out about it and he brought it to the court's attention. As an officer of the court, I commend him for doing that. But that was after the act was committed. That is, after the court was lied to and deceived. So to me, that is quite frankly the most egregious of the violations, in the sense of we have a rule of law. We all agree to abide and present evidence to this court and let an impartial party, a referee, a judge, make a determination. And what happened is here, they were lying to the court. And I say they because this defendant was complicit in doing that. It just wasn't a lady who walked out of the street. It was a lady who was married to him and wanted to mislead the court in terms of the amount of money that they had. They implied to the court, they told the court that they were injured, when in fact they had over $130,000. And so I would request that the court keep this defendant under no bond, because now you just don't have him committing a crime in terms of what the state is having charged with. You now have him lying to the court through his wife, so that becomes a more egregious set of facts that makes this a more disturbing incident or crime. And therefore, I would ask the court to continue to have his bond revoked and keep him under no bond. Thank you.
Mr. Mayor? Thank you. Just a brief explanation that, so the state's clear. The reason why the picture from 7-Eleven was brought in is to show Trayvon Martin's size in comparison to the clerk, and how he did look with the hoodie, not because he was wearing a hoodie, but it shows his size. It does stand in stark contrast to the pictures that have been out there, the airbrushed photographs. So I think it's important that...
I think you want me to rely on record evidence here, right?
Okay.
And I'm just saying, you know, there's so much out in the community about this stuff and what's going on and everything, but I think when it comes down to this, you want me to rely on record evidence.
The point being that is the most recent photograph of Mr. Martin before his untimely death, and I think it's relevant for the court to consider. And we've gone far afield of most bond motions with these mini trials. We'll get into it. My client certainly looks forward to testifying in that regard when the time is right, and the rest of the evidence is already identified. But we will then at that point see whether or not the state actually has somebody who suggests that they will testify that my client challenged him. It hasn't been disclosed in discovery yet, but that may just be a term of art between opposing parties in a criminal case. Basically, yes, they didn't tell you the truth about the money. And I'm asking not to require that he now spend the next year in jail for a crime that, now that you have a better flavor for the evidence, he may well have an affirmative defense of self-defense for, and that he may well never get convicted by a jury of his peers if the state has proven this crime or any crime beyond reasonable doubt. And I ask you not to punish him any more than you have for the fact that they did not trust you to give up, if you will, the only money that they had until 4 days later when they did.
Thank you, Mr. Mayor. I'll wait the production of the evidence and then I'll be able to make a ruling, okay?
Yes, Your Honor.
Thank you. Be in recess at this time.